Delaware has a moderately regulated breaking lease framework with specific statutory provisions that provide more structure than many states. The governing law is found in the Delaware Residential Landlord Tenant Code, Delaware Code Title 25, Chapter 55, which addresses the landlord's obligations when a tenant vacates early and the tenant's liability for breach. If you're a landlord or tenant in Delaware, the statutory framework provides reasonable clarity with tenant protections that go beyond the federal baseline. Let's start with the landlord's duty to mitigate damages. Under Delaware Code Section 55507, when a tenant abandons the property or breaks the lease, the landlord has a statutory duty to make reasonable efforts to re-rent the unit. Delaware's mitigation requirement is codified. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. The landlord must take reasonable steps, advertising, showing the property, and accepting a qualified applicant. The departing tenant's liability is limited to rent during the vacancy period plus the landlord's reasonable re-rental costs. If the landlord fails to mitigate, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable efforts. Delaware's Residential Landlord Tenant Code provides a more detailed framework than many states, specifying the landlord's obligations and the tenant's rights with reasonable precision. This statutory clarity benefits both parties by establishing clear expectations. Early termination clauses are generally enforceable in Delaware if they are reasonable. Delaware's Consumer Fraud Act provides a basis for challenging lease provisions that are unconscionable or deceptive. An early termination fee that grossly exceeds the landlord's actual or anticipated damages could be challenged. A fee of 1 to 2 months' rent with reasonable notice is typical and generally enforceable. Delaware's Residential Landlord Tenant Code includes provisions regarding prohibited lease terms. Under Section 5501, certain lease provisions that waive tenant rights under the code are void and unenforceable. A provision that eliminates the landlord's mitigation duty or that imposes the full remaining rent as liquidated damages without accounting for mitigation could be challenged under this section. Military members have the right to break a lease under the SCRA. Delaware's military population is centered around Dover Air Force Base, home to the largest aerial port on the East Coast. Dover AFB generates significant military rental demand in the Dover, Camden, and Smyrna areas. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. SCRA terminations from Dover AFB are a regular occurrence. Military personnel at the base serve assignments of varying lengths, and the regular rotation creates predictable lease break patterns. Landlords in the Dover area should have a standardized SCRA process. Delaware has enacted protections for victims of domestic violence that allow early lease termination. Under Delaware Code, Title 25, Section 5314, a tenant who is a victim of domestic violence, sexual offense, or stalking can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a valid protective order, either temporary or permanent, a copy of a police report, or a written statement from a qualified domestic violence service provider. The tenant must provide written notice before the termination date. The statute specifies the requirements for the notice period. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit must be returned according to standard rules within 20 days. Delaware's provision includes important protections. The landlord must keep the documentation confidential. The landlord cannot disclose the tenant's status. The landlord cannot use the termination as a basis for negative references or future denial. And the landlord cannot retaliate against the tenant for exercising their rights under the provision. Delaware also addresses lock changes. The victim tenant has the right to have the locks changed on the unit, either by the landlord or at the tenant's expense. If the perpetrator had access to the premises, the landlord must cooperate with lock change requests promptly. Tenants in Delaware may break a lease if the landlord fails to maintain habitable conditions. Under Delaware Code Section 5305, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises in a fit and habitable condition, keep common areas safe and clean, and maintain essential systems including plumbing, heating, electrical, and ventilation. If the landlord fails to maintain the property and the failure materially affects health and safety, the tenant has remedies under the code. The tenant must provide written notice to the landlord identifying the specific deficiency. The landlord typically has a reasonable period to make the repair. If the landlord fails to act within a reasonable time, the tenant may terminate. Delaware also has a rent escrow provision. Under certain circumstances, the tenant can deposit rent with the court rather than paying the landlord, and the court can order repairs, reduce rent, or terminate the lease. While rent escrow is not used as frequently in Delaware as in some states, it provides an intermediate remedy between complaint and termination. Delaware recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, changing locks, failing to address dangerous conditions, render the unit uninhabitable, the tenant can treat the lease as terminated. The tenant must vacate within a reasonable time. Delaware has specific provisions regarding abandonment. Under the code, if a tenant abandons the property, the landlord can retake possession after following proper procedures. The landlord must document evidence of abandonment, unpaid rent, absence, removal of belongings, before entering. The departing tenant remains liable for damages subject to the mitigation duty. Delaware also has provisions regarding the tenant's personal property left behind after abandonment. The landlord must provide notice and allow a reasonable period for the tenant to retrieve their belongings before disposing of them. Delaware legalized recreational marijuana, and landlords should be aware that marijuana-related records cannot be used against a departing tenant. For example, claiming that marijuana use constituted a lease violation that justified damages beyond normal breaking lease liability when the use was legal. From a practical standpoint, Delaware has a small but tight rental market shaped by its strategic location between Philadelphia, Baltimore, and Washington, D.C. Newcastle County, the northernmost county containing Wilmington and Newark, has the strongest market. Wilmington's economy is driven by financial services. Delaware's favorable corporate laws attract banking and credit card operations, healthcare, the legal profession, and government. When a tenant breaks a lease in Wilmington, re-rental times vary by area. Downtown Wilmington and the Trolley Square area have moderate demand. The suburbs, Pike Creek, Hockessin, Greenville, command premium rents with stronger demand. Newark, home to the University of Delaware, has a tight student market. Student lease breaks timed to the academic calendar, spring and summer, fill quickly. UD's enrollment creates strong seasonal demand. Mid-year breaks take longer but are manageable given the overall market. Dover, the state capital, has a moderate market driven by state government and Dover Air Force Base. Military lease breaks from Dover AFB are routine. The combination of government and military employment creates stable demand. Re-rental in Dover is moderate, typically 2 to 4 weeks. Sussex County, the southernmost county, has a market shaped by beach tourism and retirement. Rehoboth Beach, Dewey Beach, and Lewis have seasonal dynamics. Summer lease breaks can be filled with incoming seasonal workers. Off-season breaks take longer. Inland Sussex County communities, Georgetown, Seaford, Laurel, have more affordable markets driven by agriculture and poultry processing. Delaware's small size means reputation matters enormously, just as it does for screening. The landlord community is interconnected, and tenant advocacy organizations, including Delaware Volunteer Legal Services and Community Legal Aid Society, are accessible and responsive. How you handle broken leases directly affects your reputation. Fair, documented handling builds trust. Aggressive, undocumented claims invite complaints. One best practice for Delaware landlords: include a clear early termination clause in your lease that complies with the Residential Landlord-Tenant Code's requirements. Ensure the clause doesn't waive tenant rights under the code, which would make it void. A clause offering 60 days' notice and a fee of 1 to 2 months' rent, working alongside the statutory mitigation duty, is typical and enforceable. Another best practice: Begin re-rental efforts immediately and document every step. Delaware's statutory mitigation duty is clear and enforceable. In a small state where disputes are resolved efficiently, your documentation of prompt re-rental efforts establishes your compliance and limits disputes. A third best practice: have a standard process for handling domestic violence terminations under Section 53(14). Accept qualifying documentation, process the termination, cooperate with lock change requests, return the deposit within 20 days, and maintain strict confidentiality. Delaware's tenant advocacy organizations monitor landlord practices, and fair handling is essential. Delaware limits the security deposit to 1 month's rent for leases of 1 year or more. There is no cap for shorter-term leases, though the amount must be reasonable. The deposit must be held in an escrow account at a federally insured Delaware institution. The deposit must be returned within 20 days of the tenant vacating. If the landlord fails to comply with the escrow or return requirements, the landlord may forfeit the right to retain any portion and may be liable for double the amount wrongfully withheld. These rules apply to broken leases and normal move-outs alike. For the complete guide to Delaware breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.